So the judge is essentially saying, I warned you, I gave you plenty of opportunities. We burned through 8 attorneys to get here, and your own conduct, you have essentially waived, or more correctly, forfeited your right to have counsel. You do not have a right to an unlimited and frivolous use of public resources. After bulldozing her way through 8 attorneys, notorious suitcase murderer Sarah Boone now tells the judge she has buyer's remorse and no longer wants to represent herself. Plus, did the jury actually intend to acquit Karen Reed of murder for the death of her Boston police officer boyfriend John O'Keefe? And more importantly, what is the judge going to do about it? All this and more this week on Courtroom Confidential. Hello, all of my Courtroom Confidential friends. We have an exciting special announcement before we jump into this week's cases. We have been working very hard behind the scenes to continue to try to offer you more and more content and interactive experiences. And the next big step in that direction is that this morning, we are excited to be offering Courtroom Confidential memberships. I won't get into all of the details right now, but if you look on our YouTube page and click on the Join tab, you can get a full breakdown of all of the new offerings and benefits, from members-only content and merchandise to exclusive live streams and more. So please check it out, and we hope that you will join us on this exciting new journey. All right, let's jump right in. Accused suitcase killer Sarah Boone appeared in court on Monday, where she failed to convince a judge to give her another chance to have a lawyer represent her. The Florida woman is facing a second-degree murder charge for the death of her boyfriend, Jorge Torres Jr. in 2020. Boone is accused of convincing him to get inside a suitcase, zipping it closed, and refusing to let him out. When she opened the suitcase the next day, Torres was dead. Orange County Circuit Judge Michael Kranick, who is presiding over the case, ruled that Boone forfeited her right to legal counsel on June 28th after she went through 8 lawyers. Several cited irreconcilable differences as their reason for resigning. Boone appeared in court on Monday for a hearing on several handwritten notes she had submitted from jail, including one for, quote, standby counsel. Judge Kranick denied Boone's request, noting, as the court has determined that you have forfeited and alternatively waived by your conduct your right to court-appointed counsel, the court is not required to appoint standby counsel. Boone fired back, I do not forfeit my right. That was your judgment, she complained, and also, I feel that I should have some kind of evidentiary hearing prior to your decision so I could have a better chance at explaining myself and your understanding. I don't want to be pro se any longer. I didn't want to be pro se in the first place. In response, Kranick simply replied, denied, period. All right, what's happening here? Well, first, I think it's important for us to understand what the right to counsel is. The right to counsel comes from the Sixth Amendment, and it includes many things in that amendment. It includes your right to a speedy trial, to not have it delayed for an unreasonable reason, your right to have an impartial jury, and the right to have the assistance of counsel for your defense. And through interpretation of the Constitution and, hundreds of years later where we find ourselves, is that you can have an attorney appointed to you if you cannot afford one. That's essentially what that right is saying, is that no person just based merely on their financial circumstances is going to be left without an attorney in this country. And that's why many counties, many court systems have a public defender's office that is set up for that primary purpose of satisfying the constitutional requirements of counsel, to have a public defender's office so that people who come in and are considered indigent and unable to hire their own attorney will have an attorney appointed to them. Other counties that don't have a public defender's office, smaller counties, have an appointed counsel system where if you're a lawyer in that jurisdiction, you may be getting a call from the local judge saying, by the way, I'm assigning you a case as part of your responsibilities for practicing in this county, and you're going to be representing this person at trial. You hear many amazing stories that come out of attorneys' experiences with that. But the other thing to understand is that you can waive your right to counsel. You can waive your right to almost any right. People do this all the time. When you take a plea agreement, you're waiving your right to testify against yourself. You're waiving your right to have a jury trial. You're waiving your right to cross-examine people. People waive rights all the time. So that is not entirely uncommon. But the issue that's unique in this case is the question of whether or not you can forfeit one of your rights by your conduct. And that is what the judge is saying took place here. She didn't make a voluntary waiver. Even in Sarah Boone's own comments, she says, I don't want to be pro se. I don't want to represent myself. I've never wanted to represent myself, and I've never waived my right to have counsel appointed to me. The judge is saying, however, by your conduct, I am interpreting that as a waiver and essentially as a forfeiture of your right, of your Sixth Amendment constitutional right. So this is no small deal here, folks. He's saying your conduct has essentially paved the way for you to forfeit one of your constitutional rights. Now, can that be done? The answer is yes. How often is it done? Almost never. Is it rare? Absolutely. What are the procedures that have to take place in order for someone to forfeit a right? Well, first of all, they have to be warned. I think she has been warned here. And in fact, she had 8 opportunities to have counsel appointed to her, and she just couldn't, through her own conduct, which is important, seem to work any of that out. So she did receive a warning. Was her conduct the problem? Absolutely. Every single one of these attorneys who withdrew said that they cannot get along with this person. And it's not a matter of personality differences. Let's be clear about that. There is something fundamental about the way that Sarah Boone conducts herself with her attorneys that make it impossible for them to represent her. Now, people are allowed to be difficult. People are allowed to be hard to get along with. People are even allowed to be rude to their attorneys, and their attorney can't walk in and say, I want to withdraw from this case. But no attorney is expected to put up with abuse. That's what we've come to. That's where we've arrived at with her conduct. So the judge is essentially saying, I warned you. I gave you plenty of opportunities. We burned through 8 attorneys to get here, and your own conduct, you have essentially waived, or more correctly, forfeited your right to have counsel. You do not have a right to an unlimited and frivolous use of public resources. Bear that in mind. He's just saying, I'm not going to appoint counsel and have it paid for by the taxpayers of this county in order for you to have an attorney. She can still go out and hire her own attorney. No one is denying her the ability to have an attorney. If she can find an attorney that will put up with her and she can pay for that attorney, she can go ahead and bring an attorney into court. But in the meantime, this Sixth Amendment right to have counsel appointed to you for free, paid for by the government, has been denied based upon her conduct. Is that the right move here? We'll get to that in a minute. Now, what is this idea of standby counsel that she's asking for? When you have a defendant represent themselves, and I've experienced this a few times in my career, it is a safe move. It is a safety net to have what's called standby counsel appointed. So this is someone by the public defender's office or the alternate public defender's office or private counsel who's appointed to basically sit there and take notes. They're not allowed to participate. They're not allowed to give advice or counsel to the defendant. They're just simply sitting there to take notes. Well, what's the purpose for that? If this whole dog and pony show falls apart and the defendant who's gone pro se decides all of a sudden, you know what, I can't handle this. I don't understand what it's like to be an attorney. I guess going to law school does count for something, and I cannot handle representing myself in this most important forum where I may be going to prison for a very long time, and I want out. In that situation, if that happens, rather than declaring a mistrial and the whole thing is over, they just simply have standing counsel step in. And that person has been paying attention, and that person has not been participating, but taking notes. That person understands the evidence, and that person could essentially just grab the baton and bring this whole mess to the finish line. Now, the judge denied her standby counsel in this case. And that to me is an interesting move, and also perhaps a, disastrous move. I don't know. We will have to see how this case works out, because I can almost guarantee you this trial, if she represents herself, is not going to go smoothly. And at some point, she's going to raise enough of a stink to say she doesn't want to represent herself during trial. She's already doing it. So the idea that he's not appointing standby counsel is very curious to me. Now, his reason for that is saying because she has forfeited her right, her Sixth Amendment right to have counsel appointed, that he is not obligated to have standby counsel appointed. Okay, I guess I understand that. I guess I can wrap my head around that. I guess I don't see any clear violation of the Constitution by doing that. The Constitution doesn't entitle anyone to standby counsel. But where he might be technically right here, he may be practically asking for trouble. And I think that is what's going to happen. And I'm curious is if this judge is just at his wit's end and is no longer in a mood to extend her any other courtesies, and is just saying, lady, you have squarely made your bed, and now it's time for you to sleep in it. You cannot deal with an attorney. You're going to represent yourself, and there's no safety net. I think it's going to backfire. But what do you guys think? Is the judge making the right call here? Is this case headed for the dumpster fire Hall of Fame? Or do you think that somehow miraculously we're going to see another attorney show up, or we're going to see Sarah Boone actually represent herself at trial? Please let us know in the comments. All right, moving on. Questions and confusion continue to build before the Karen Read hearing scheduled for this Friday, August 9th, the same day that we are releasing this episode that you're watching right now. Folks, one of the downsides of bringing you coverage on breaking news is that sometimes the stars simply do not align, and we are releasing an episode on the same day that news on that case may be happening. But in this situation, have no fear. We are going to live stream the Karen Read hearing. So tune in at 2 p.m. Eastern, 11 a.m. Pacific to this channel, or you can catch the live stream later where it will live permanently on our channel. In the meantime, though, heading into the hearing, yet another juror has recently reached out to defense attorney David Yannetti to clarify to him that the jury did not think Read knew she hit her Boston police officer boyfriend, and that they found her not guilty of 2 of the 3 charges. New filing on Monday indicated the jury determined that even if Read hit John O'Keefe with her Lexus SUV, she did not realize that she had. Read was tried earlier this year for allegedly hitting her boyfriend, Boston police officer John O'Keefe, with her black SUV outside of a home in Canton in January of 2022. Her defense contended that O'Keefe was dragged outside after he was beaten up in the basement and bitten by a dog at a fellow Boston officer's home. At the end of the trial, deadlocked jurors sent a note to Judge Beverly Cannoni on July 1st indicating they were at an impasse and future deliberations would be futile, ultimately ending Read's 2-month trial. In another unusual turn of events, prosecutors in the case have now filed a document with the court indicating that jurors are reaching out to them as well to say they agree with the defense position on jury deliberations. Norfolk County District Attorney Michael Morrissey said that jurors have reached out to the prosecutor who tried the case, Adam Lally, to say similar things. Lally received the first unsolicited voicemail on July 21st from someone who identified themselves by their full name and seat number. Morrissey noted in the filing that Lally did not engage with the jurors because ethical guidelines prevented attorneys from discussing jury deliberations. All right, well, what's happening here? I'm at a loss. I'll be honest with you. I have never in my career seen anything like this. You rarely ever hear from jurors after a case is concluded. And for this many jurors to now be coming forward, for all of them to have this kind of misunderstanding of what their role was supposed to be and how they were supposed to indicate whether or not they had reached a verdict, for all of them to have been confused, and now all of them coming forward. But I should correct, not all of them, which adds further to the confusion. We don't know how many of them have reached out. It really is, uncharted waters. I don't know what to do here. I don't think there's even case law exactly on how to handle this situation. So 2 things to think about. 1, what should happen? And then 2, what will happen? What should happen is the Commonwealth should dismiss those charges. Let's put this entire mess behind them and move on with your case if you choose to do so. And there's a lot of reasons to go ahead and do that. 1, you now know how jurors likely feel about your case. I mean, you have had a 2-month-long mock jury trial on how this whole thing will come out. And there's nothing that you're going to do to improve your case. You've presented every witness that you wanted to present. You got all of the evidence in that you wanted to get in. I don't remember there being any rulings that I thought entirely hamstrung the Commonwealth's position. And in fact, for a bunch of developments that if you've been following this case, you're all aware of, since the time of the trial, this case may in fact be worse on the second go around. So that's reason number 1. Reason number 2 is just be smart and avoid all of this nonsense that could keep this case locked up in appellate hell for months. Be done with it. Foreclose the issue. They want you to dismiss counts 1 and 3. You've already had 12 jurors tell you that they don't think you had enough evidence for counts 1 and 3. Get rid of them. You still have 1 count, probably your strongest count of all, probably the argument that you had the strongest evidence to support. Pursue that if you want to. If you want to. Go ahead and pursue that. And it sounds like if these jurors are to be believed, or not the jurors, but if what we're hearing from the jurors is to be believed, they were actually leaning towards conviction on that 1 count. So go ahead and just dismiss it. Put all of this behind you. Don't have to worry about how this is going to be argued and dealt with at a higher court on a different day. Just move on with your case. Now, what will happen? Cannoni's going to deny the motion. That's what's going to happen. A mistrial was declared in this case. The defense did not object to that mistrial, and no fault to them. They didn't want to. They didn't want to, folks. All of a sudden now you hear them arguing about a mistrial. The rug was pulled out from underneath them and a mistrial was declared prematurely, and the judge was quick on the trigger to declare a mistrial. No. They wanted a mistrial. Believe me, you're a defense team. You've gone all the way through all of this, and now you realize that you're at a point where your client is going to go home that evening, not go to jail. You want a mistrial. They didn't know which way this jury was leaning. They certainly didn't know anything about jurors acquitting her on some of the counts. They had no idea. This jury could have been 10-2 for guilt, and a mistrial would have been considered a victory in their book. The defense, for the most part, wants a mistrial. Now, I'm not calling into question here how strongly they felt about their case and whether or not they felt that they proved their case and whether or not they felt that this was leaning in their favor. Fine, all of that. I'm just saying, having been there many times before, you're sitting there as a defense attorney and you know you're about to get a mistrial out of this thing. You're going to take that 9 times out of 10. And they didn't know which way. They didn't know all the mess that was taking place behind those closed deliberation room doors. The other reason is, how would you even do this? If the judge wanted to somehow pull an acquittal out of the mouth of this mistrial, how would you go about doing that? How do you reconstruct a deliberation? I know that there are jurors coming forward and saying we all agreed upon that. Well, they didn't indicate that to anyone. We don't see a vote on that. None of them were asked any of that on the record. How are you going to get are you going to get all 12 of these people back into court? Just when you start to think about all the problems and all the things that need to take place for this to actually happen, it's not going to happen. And the judge, I think she's a good judge. I know many of you may disagree with that. I think she's a good judge, and I think she will say no objection was lodged at a timely manner. This case was declared a mistrial. Motion denied. You want to take that up on appeal? have at it. Good luck to you. It's not going to happen here in my court. That's what's going to happen. I really think that having been in these courts and understand how trial judges at this level deal with things, they would much rather have a higher court tell them and do all the research on this case of first impression and give them guidance rather than make the call themselves. By the way, one last point on this. The defense can learn from all of this too. You'll notice that of all of the jurors, what they were saying was they did not believe that she meant to or knew that she hit him. But I don't think we've heard from one juror who said that they buy the conspiracy theory, that they thought, yeah, we thought he got bit by a dog. Yeah, we thought he got beaten up inside of the house and dragged outside. I don't think one of them has said any of that. They're all just saying the intent issue was at play. They all had problems with whether or not she intended to do this, which I'm going to pat myself on the back a little bit and say that that's what I've been saying all along. And it was shocking to me that neither side, especially the prosecution, did not dwell more upon that, because that was the problem with this case from the beginning. Did she intend to do this? Not whether or not her car hit him. I know all of you feel very strongly about that one way or the other, but from the prosecution's perspective, I think this case really came down to intent. They didn't talk much about it. The defense didn't go anywhere near it because they had this entire theory about, cover-ups and planted evidence and dog bites. Fine on them. It seemed like it may have worked a little bit, but I think at the end of the day, if we're all these jurors, what they're telling us, we can believe. They're saying, hey, we just didn't believe that she meant to, not that she didn't actually do it. Okay, I've had my piece. I've said what I'm going to say. Let me know how you feel about it in the comments. I know that by the time that you are watching this, we may already have a ruling on this. So let me know. Did I get it right? Did I get it wrong? And do you agree? Please let us know in the comments. All right, before we dive into the other cases making headlines this week, I only ask this one very small favor from you. If you haven't already, please take a moment to subscribe to this channel and now join us as a member, please. We look forward to continuing to provide you with even more content every single week. And don't forget to check out Courtroom Confidential as a podcast. Please join our community on all of your major podcast platforms. Also making headlines this week, a Massachusetts woman accused of fatally stabbing her husband has been found guilty of second-degree murder. Christine Ricci faced one count of murder for the death of her husband, Gulf War vet and Boston firefighter Michael Ricci. At the time of the deadly incident, Ricci claimed her husband was in the throes of a manic episode and became violent, causing her to brandish a kitchen knife in an attempt to scare him. Last Friday, after only 3 hours of deliberation, the jury came back with a verdict of guilty on second-degree murder. Her sentencing hearing is scheduled for August 22nd. Ricci, aged 46, faces up to life in prison. A New Jersey father convicted in the death of his 6-year-old son was ordered to spend 25 years in state prison at his sentencing hearing last Friday. In May, a jury found Christopher Gregor, age 32, guilty of aggravated manslaughter in the death of Corey Micciolo, who prosecutors argued died from injuries sustained from chronic abuse. This case was made infamous for surveillance footage from a fitness center at Gregor's apartment complex showing Corey running on a treadmill as his father continually increases the speed. In the video, the boy stumbles and falls multiple times as he attempts to keep up. Gregor can be seen grabbing Corey by the shirt, and at one point, he appeared to bite the child's head. At the sentencing hearing, Judge Guy Ryan noted that he had received hundreds of letters from people around the country wanting to weigh in on the sentence. An Ohio man has been sentenced to life in prison without the possibility of parole in the shooting deaths of his 3 young sons. A Claremont County judge sentenced Chad Doerman, age 33, on Friday to 3 consecutive life terms after he pleaded guilty to aggravated murder charges. The state had originally vowed to seek the death penalty in the June 15, 2023 murders of Doerman's 3 sons aged 7, 4, and 3 in Monroe Township, about 75 miles west of Columbus. But on Friday, prosecutors cited the trauma that the surviving family members experienced that day and continue to experience on a daily basis as a reason for the change of plea. My job, as I saw it this week, the prosecutor said, was to relieve them of that additional agony. Double murder suspect Richard Allen was in court last week for a 3-day hearing at the Carroll County Courthouse in Indiana. Allen is accused of the notorious Delphi murders of Libby German and Abby Williams in 2017. He was arrested in 2022. The hearing spanned a wide range of topics, including testimony from 9 total witnesses. As attorneys from both sides sparred over issues from alleged discovery violations and motions to dismiss, one bombshell revelation came when the defense made an argument to suppress evidence of statements made by Allen since his incarceration. According to the prosecution, Allen made at least 61 incriminating statements in the first few months after his arrest while being held in state prison for safekeeping. Much of what was argued over the 3 days of hearings are being taken under advisement by Judge Fran Gull, who will issue her rulings at a later date. Before we get into what's on the docket for next week, I wanted to take this time to thank you all for your support. The love from this growing Courtroom Confidential community has been absolutely amazing, but we would like to give a special shout out to C Green for their wonderful review on Apple Podcasts, and to NHL Pens 583 from Montana and Scurvy Elephant 333 for their kind words on YouTube. Keep them coming, folks. We always highly appreciate your feedback, and tell us where you're from. We are very happy to hear from our growing international community. On the docket next week, the murder trial for former Clark County Public Administrator Robert Tellez is set to begin on Monday. Tellez is accused of killing veteran investigative reporter Jeff German in September 2022 over articles the journalist had written about Tellez conducted as a public official. Tellez has pleaded not guilty to the murder charge and has maintained he was framed for the killing. As we discussed previously, Karen Reed is due back in court August 9th, the day we are releasing this episode, so please make sure to check out our live coverage on the Courtroom Confidential YouTube channel today. Finally, coming again this Tuesday, Courtroom Confidential is very proud to bring you another very special episode in our Case Notes series. When an avid fitness enthusiast and mother of 5 went for a jog on a wooded trail in suburban Baltimore in August of 2023, no one could have imagined it would be the last time she was seen alive. When her battered body was found the next day, an investigation would unfold over the following months that would lead investigators across the country and beyond. Join me this coming Tuesday as we dive into the murder of Rachel Morin. Well, that is it for us this week, folks. I'm your host, Josh Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.